Hey, welcome back to the Law and Crime Network. We're still covering the Anthony Kirkland trial in Ohio. Again, he was previously sentenced to death. However, the Supreme Court said he could actually get a new trial to decide if he should still die or if he should receive life in prison. In studio with me right now, my friend here on the Law and Crime Network, Aaron Keller. Thanks for joining me.
What's going on?
You know, I thought you were already gone for the day.
No, I'm always lurking somewhere behind what people
the scenes.
Can see. Yeah.
Right. Thought you were on the train. So this is a really interesting case. Like, I don't think I've ever heard of where someone has already been sentenced, convicted of death, where they actually get a new trial because of something the prosecutor said, which the Supreme Court agreed that wasn't actually fair for the defendant in this case. Have you heard of this much?
Well, look, I mean, it happens, but it's very, very rare, and it's rare how it got there. I mean, thankfully for prosecutors, they don't have to retry the entire case.
Right.
Okay, this wasn't an error with the guilt phase, it was an error with the punishment phase. So they just have to redo the punishment phase. The problem for prosecutors, though, is that because usually the same jury hears the guilt and the punishment phase,
right.
Okay, they can sort of, go back on what the jury heard in the first phase of the case to play off of that for the second phase. Here they can't do that. They kind of, sort of have to redo the entire case because this jury knows nothing about the facts.
That's exactly right. It's a entirely new jury. They probably don't know about this case. It happened many, many years ago when he was actually convicted, I believe, back in 2010. Mm-hmm. So even if you knew about it, you've probably forgotten about it. So you don't have to retry the entire case, but you actually have to set the stage to say, hey, this is a bad guy, and he needs to have the death penalty. So how do you do that without retrying the entire case?
Well, I mean, it's not, they don't have to in a legal sense, but they have to from a factual sense. So they've got to bring all the witnesses back to remind or tell these jurors for the first time, I should say, exactly what happened during the crime. A lot of times the punishment phases of a trial, they build on what had already been done in the first phase. Well, this jury didn't hear that first phase. As to the question of how often does it happen legally, is it strange? This happens from time to time. Some states keep prosecutors on shorter leashes than other states. But the bottom line is, it's a constitutional paradigm that if we're going to convict someone and send that person to death row, then that defendant's rights need to be scrutinized. And here, that's what the court did. It's interesting that the first time the court looked at the case, they said, well, the prosecutor was out of line, but they didn't require a new hearing. And then the Supreme Court, this is what's really rare about it, the court turned around and said, we're going to reconsider it. That's really, really rare for an appellate court to reconsider. And when they reconsidered, they said, okay, yeah, it was a problem, but we agree it should result in a new hearing. That's why we're here today. That's the really rare part.
Yeah, that doesn't happen too often. We actually want to get back in the courtroom and actually hear from the defendant himself. This is part of his police interview. Take a listen to what Anthony Kirkland had to say. Okay, that was very crucial audio from Anthony Kirkland here in this case. Again, he's the defendant in this case, and he mentioned to that investigator that he was at Daly Park. Now, what's important about that? One of the victims, Esme Kinney, was actually found there in that park. So he actually just put himself in the area where one of the victims was found. Aaron, how crucial is that? Now, of course, during that testimony, he didn't say anything about, oh, I came across this 13-year-old and we had a discussion, but he puts himself in the area. He puts himself in the area.
Okay, it's important, but it's not crucial. So if we look at it from a standpoint of relevance, relevance is best defined as a needle, okay? Information that makes your case less or more provable is relevant, okay? Mm-hmm. Anything that budges that needle but a little bit. So if you're asking me, a particular fact, and I say, let's say, the fact we're trying is what color this table is. Well, whether the sky is blue is completely irrelevant. It doesn't move the needle one way or another, but did we go out and buy walnut-colored stain? That's relevant. Here, it's relevant that he was in the park where the victim's body was found. That's relevant. Is it the smoking gun? Is it a huge piece of this? Not a huge piece.
Right. You're right, because, I mean, he could have just been at the park walking a dog or out for a Sunday stroll. We don't know.
We don't know what he's up to. He's starting to get there, though, and that's the key, is they're starting to narrow this in on more critical facts. And the closer they get, of course, the more of a fear, as you know, that he'll invoke right to counsel or invoke right to silence, and he won't say anything more, but they at least got him in the area.
Absolutely. We're actually going to take a quick break. We'll come right back here at the Law and Crime Network, switch gears to the Demetrius Elder case in Florida, a manslaughter case. You don't want to miss it. Stay tuned. We'll be right back. Hey, welcome back to the Law and Crime Network. Switching gears, we want to get back to Florida and Demetrius Elder. Now, this is a case, a manslaughter case, where Demetrius, who's on trial right now for manslaughter, initially attempted the stand your ground law. Of course, that became really famous during the Trayvon Martin shooting and George Zimmerman in the state of Florida. That's when most people started to understand what the stand your ground law was. But the judge threw that out. There is a trial right now going on that we've been covering for the offense of manslaughter. Still with me here in the studio, Aaron Keller. Aaron, how do you prove, right? So we have this victim, we have this defendant, we had this argument, apparently a road rage incident. How do you prove it wasn't self-defense in this case?
Well, from what the testimony revealed, the prosecutor was getting some neighbors who witnessed some of the altercation, and then turn around and say it didn't roll out this way. There was nothing that would have made the defendant feel as though he was in reasonable fear for his own safety. You know, this didn't look like an attack. The victim wasn't right up in the defendant's business,
right?
And they're pitting words of some disinterested and therefore presumably unbiased witnesses against the words of the defendant in that stand your ground hearing.
Yeah, and it's interesting. I always say it's interesting, especially with stand your ground. If the person is not in your personal space, if there's not that, what we call in police work, imminent
threat.
Right. Then how can you justify stand your ground? I'll be interested to see how the jury goes on this. We actually want to hear testimony from the victim's girlfriend in this case. And let's take a listen to what she had to say on the night of the murder of her boyfriend. Okay, that was testimony from the victim in this case, Mohammed. Again, Demetrius Elder is on trial right now for manslaughter. This started as a road rage incident that occurred between both parties. Apparently, the victim in this case was behind Demetrius Elder's vehicle. Something occurred there at the stop sign. It got really heated. Still here in studio with me is Aaron Keller. Aaron, I noticed something during that testimony that I kind of got to play devil's advocate, right?
Okay.
It's a road rage incident. There's probably some four-letter words going on. It's really heated. It's late at night. No one expects for someone to reach out and shake their hand. So could it be that Demetrius Elder actually believed that there was an imminent threat? Because you heard that testimony. He walked back as if he was going to shake his hand. Maybe he thought he had a gun, a knife, or something like that. Could that be the case?
I mean, it could be, and certainly that's what the defense would like to have people believe. I think that the struggle for the jury here, and like this is why we have juries, is figure out whose version of this is correct and whose version of it isn't. Because one of the last witnesses when the case was still live presented, at least from what I recall, a version of this that wasn't anywhere near what the defendant and some of the other people said was going on here. So whose story is the jury going to believe?
Yeah, and that's interesting. There's a co-defendant in this case who I believe is on the witness list, but do you think he'll testify? Because if he does, that could actually jeopardize his case. I think if Baptiste is called to the stand, I think he'll plead the fifth, because like you said, their story versus other stories aren't matching up with what the jury's being told.
Well, it depends on whose witness list it is. I mean, if it's the defense witness list, I'd be certainly curious because, you know, is he going to testify on behalf of his companion who was in the vehicle with him? You know, boy, that's interesting. But you never know what might happen, I guess, in court.
Yeah, and it sounds like at one point the co-defendant was an aggressor in this case, because we just heard that testimony that he stepped out of the vehicle.
You know, they might start blaming it on one another. You never know.
Right, you never know. I mean, That's what happens when things go to trial. We're actually going to take a quick break, have more of the Demetrius Elder case in the state of Florida. Again, this is a manslaughter case which originated from a road rage incident. Stay tuned to the Law and Crime Network. Hey, welcome back to the Law and Crime Network. We're still covering the Demetrius Elder case in Florida. He's on trial right now for manslaughter after a apparent road rage incident. And what happened that night is in dispute, of course. Obviously, that's why we're on trial here. Aaron, you and I were talking during the break, and this is a manslaughter charge. How come this is not a first-degree murder charge in the state of Florida?
Well, it's not a couple of other charges for specific reasons, okay? And people who watch the trial always go into the statute and look and see what it is the prosecution has to prove, because it'll indicate why they're presenting certain evidence. First-degree murder in Florida is a murder committed in a number of specific different ways. Either it has to be premeditated, okay, they have to prove beyond a reasonable doubt that it was thought up ahead of time, that someone wanted and planned and plotted to kill someone else, or it has to be a murder within the commission of another specific type of crime. No evidence of that here. That's off the table. Second-degree murder has to be a person in a depraved mind, okay? No evidence of that here. It drops down to manslaughter because that's the catch-all that encompasses any other killing without a depraved mind, without the elements required for first-degree murder. So manslaughter, the killing of a human being, basically in other ways that is just not the other charges. This is just sort of the catch-all statute.
Right. So the prosecution was smart in their charging order in this case. I think back to a few years ago when George Zimmerman was on trial for first-degree murder, and the prosecution never dropped that down to manslaughter. And once that happened, I knew he was going to walk because, like you said, the premeditation wasn't there. They could not prove that George Zimmerman set out that night to kill Trayvon Martin. And that's why, contrary to what people believe, George Zimmerman walked in that case because he was overcharged.
Was it a case where, and I don't remember the specifics of that one, I mean, they could have tried to go forward and say that the defendant formed the premeditation in an instant, because it doesn't need to be this lengthy, months and months of nefarious plotting. It can be formed in a very quick period of time, but there needs to be a specific reason for it, okay? The state could have thought that it had it. I mean, look, they got it beyond a probable cause hearing.
Right.
Okay. So there must have been something there. But the question is, why didn't the jury then convict on a lesser included? Or it may just be that the jury didn't do that because the jury was ticked off that the state, to quote one of my law school professors, wanted to go for the whole enchilada and failed miserably in doing so.
That's right. And sometimes enchiladas give you gas. Trust me.
Juries tend to not look favorably on prosecutors who oversell cases.
That's right. We're going to switch gears, get back in the courtroom. Here's some testimony from Corey McMath. He's actually a friend of the victim in this case, Mohammed Knight. Take a listen to what he had to say. Okay, that was some pretty interesting and crucial testimony from Corey McMath. He's a friend of the victim here in this case, Mohammed Knight. And we just heard him testify that basically Mohammed was leaking blood, as he described it, and he went to get some towels to try to cover up those wounds. We believe he was stabbed 5 to 6 times, according to previous testimony. And he also says he called 911. But Aaron, what I got out of that testimony, which I think was very crucial in trying to paint this picture here, is he says Mohammed was not physically violent because he wouldn't allow it, especially at his house. I assume the party was at his house. He just said it was his birthday the day prior. So he's saying that the victim in this case was not violent. So
again, who do we believe?
Who do we believe?
Who do we believe? There's a number of different versions of this story. So this is why we saw contested testimony. It's why we saw the testimony of the defendant from the Stand Your Ground hearing coming into court later on. It was earlier this afternoon, but after this testimony. And, jurors are going to have to try to sort this out. This is a jury that is being asked to split the hair between a lot of competing facts. And oftentimes we don't ask quite that much of jurors.
Right. And you heard there at the end of this testimony that Corey was actually getting a little upset and being defensive here. Like, what does this have to do with the murder? He's dead. What does this have to do with the murder? So as a juror, I'm sure that's playing in their head like, so why are you getting so upset? You say he wasn't a violent person. So I think you're right. There's a lot going on here. Who do we believe? Who do we believe to say, yes, there was that imminent threat of danger there, or there wasn't that imminent threat? We heard testimony. He went to shake the hand, or what the girlfriend said, he was going to shake his hand, and then things escalated from there. So who do we believe in this case?
Who do we believe in? We had a lot of evidence practice this afternoon trying to keep out specific impeachment testimony, trying to keep out certain character evidence, because here we've got a lot of back and forth about the victim's character, and one of the evidence rules about character evidence gets into a lot of, okay, well, you know, if the defendant raises the victim's character, then the prosecution can go back and attack the defendant's character, as well as say that the defendant is mischaracterizing the victim's character. This character evidence just goes around and around and around. And here we have a interesting example of a trial that's focused on it.
Yeah. Aaron, you like giveaways? You like free stuff?
Depends on what it is.
Yeah, we got one here at the Law and Crime.
This is a good one.
This is a good one. We have one here at the Law and Crime Network. You'll see it here on your screen. There it is. Go to lawandcrime.com. Enter to win the ultimate true crime giveaway. 2 tickets to CrimeCon 2019. I believe it's in New Orleans this year. That's a great city. You get to meet the Honorable Dan Abrams, who you see everywhere, Law and Crime, ABC, Live PD. Go to lawandcrime.com. Enter for your chance to win. We'll be right back here on the Law and Crime Network with more of Demetrius Elder in the state of Florida. Stay tuned.